Was it the right decision? I mean, life is full of judgments, right? And I'll get back to AI. Was it the right decision not to cancel this event? This is not just a rhetorical question. It's actually a very, very, very good question. And it'll bring us to what I want to talk about, which is really AI. And I think everybody understood how I'll make that bridge. Anybody read the book System 1, System 2? Think Fast and Slow by Kahneman? You did. One of the best books I ever read. Nobel Prize for Psychology, very, very well deserved, very well earned. In which he delivers absolutely astounding evidence of the fact that we are not rational beings. We are completely irrational. This mythology of Homo sapiens, which unfortunately has developed into Homo sapiens with a Z because we have our philosophy stone where we don't have our brain, no longer even applies. We are completely irrational beings. And in a speech I gave recently for UNESCO, I even used the term Homo odiens. You know what that means? It means the only creature in the world that is capable of conceptual hatred. That is what we are. But let's not talk about that right now. I'll get back to hate speech later. We are irrational, completely irrational. So maybe it was the rational decision not to cancel this event. If we just look at the probabilities, if we just look at the statistics, it's probably more dangerous to drive home by car than to participate in this meeting. Yet there are so very, 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 very few of you that turned up. Why is that? Why did we pass this judgment, which is completely irrational, with the consequences that now the US has closed all air traffic to their country? And we've seen the worst financial slump since 1987. Is it rational? Well, if you ask the medical environment, and if you ask statisticians, it's not rational. We have schools that are going to be closed down completely in France next week. And probably the same is going to happen in this country. Unless the politicians know some things that we don't know, it seems that it just confirms Kahneman's theory that we are not rational beings. Now I say that because the subject that I really want to talk about is artificial intelligence. Those of you who have read the article that I think you distributed, my article, on human rights and accountability in the Privacy Journal, will probably be surprised at what I'm going to say now, because it's completely different from what I wrote in that article. I changed my mind. I'm not in any way ashamed of changing my mind. I think one should change one's mind if one was proven wrong. What I argued very strongly in that article about 6 months ago was that AI is an intrinsically biased way of manipulating people. It actually consolidates gender inequality. It consolidates the digital gap. And it also causes us in many ways to reinforce economic inequality. That may be true, that may not be true. But recently, I experienced something very interesting. And I'll get back now to the justice system. I guess you're all lawyers in this room? You're not. Okay, I guess that most of the people that are listening in on this are lawyers. How many of you have ever visited a prison? Why have you visited a prison? Because this is your work, your job? Okay. Has anybody in this room or in the streaming here ever been held in custody or in detention in a case? You know, the famous 24-hour rule, the Magna Carta rule, right? Completely innocent, you're just kept there because there's an investigation going on, and they let you go after 24 hours. Well, as a lawyer in private practice, I actually have seen how this works. Without naming countries, I can tell you that in many European countries, And you wouldn't believe with the countries that I'm talking about here, but I promised myself not to name them. You're put in a cell during the detention period, the custody period. Tomorrow it could be anybody in this room, together with 3 or 4 or maybe 10 other people, a cell where you can't sit down because there are no chairs, there's nothing. You don't get anything to drink, don't get anything to eat. They take your watch away, they take your shoes away, your belt, and you're kept there for 24 hours. And then maybe or maybe not, you'll get to meet the judge and they'll release you. This is extremely interesting. Of course, the official reason given why they take away your watch and why they don't allow you to know what time it is that, oh, you may hurt yourself because somehow your watch may hurt yourself. Come on. This is just psychological torture. And several reports from the Council of Europe have actually already identified that. Because some police officer or some judge decides that that is what that person arbitrarily and subjectively thinks should be done in that particular situation. Now, would artificial intelligence help us here? And this is my metamorphosis. This is where I changed my mind, because I saw how this works. And my conclusion is yes. I would actually suggest a new human right, a new procedural right, which would be to say that anybody who is in custody, anybody who is suspected of a crime, anybody who is in prison should have a right to have the facts, and only the facts, because we live in a country where it is, at least in theory, the evidence that counts, have that fact crunched by a machine, call it an AI machine, and have a second opinion as to whether the basis for that judgment was rational or irrational. Because we are not rational beings, and the judges are just like the rest of us, and the police officers are just like the rest of us. So having made this intro, which I think is very important to the rest of my discussion here, because I hope this will develop into discussion, let me just make a few remarks about AI. We use this as a generic term, artificial intelligence. And it's not that I want to go into semantics and discuss at length the programming definitions of artificial intelligence as opposed or compared to machine learning, algorithms, big data, and so on and so forth. But it seems that today that when we talk about artificial intelligence, it has really become a generic term covering everything, also classic algorithms. I'm not going to challenge that. I just want everybody in this room to know that I do not share that opinion. Artificial intelligence is a technology in its own right, very different from algorithms, very bit different from big data. But again, for the purposes of this session, let's just stay with that. Now, there are two different kinds of artificial intelligence. And now I talk about true artificial intelligence, not the generic term. Typically, you divide them into the following two categories. One is the rule-based, one is the neuron-based. The rule-based artificial intelligence is very close to classic machine learning, which is really, the if A, then B. If B, then C, and so on and so forth. That's the rule-based, equation-based machine learning artificial intelligence. Sometimes it works, sometimes it doesn't work. What happened was that especially companies like DeepMind, which now was taken over by Google, and IBM's Watson, famously winning the chess game, as you know, and DeepMind winning the Go game, were based on a different technology. That technology is the neuron-based AI. And that is the one that really is the AI that we should be talking about if we talk about AI, the neuron-based AI, which is trying to mimic and copy the way our brain works. So it's a set of filters, to simplify. It's a set of filters, again, mimicking the path of our synapses and neurons in our brains and finding out how, when you put data into one end of this machine, a result comes out of the other. The difference is very important because the people that do neuron AI, which is again AI today, they don't know what comes out on the other end. It's not like doing the equation where actually you control the result. Most of the programmers that do artificial intelligence have no idea what the machine that they are creating actually does at the end of the day based on the data that they feed it with. And I think that is extremely important. Because when we talk about including ethics in programming and including mandatory courses in ethics at different universities around the world, and I've had occasion to see the curriculum in such universities, there is an ethics part, typically 2 or 3 hours that nobody attends. And the program is typically one of explaining ethical views which are more or less trivial, rather than explaining the different schools of ethics that could be interesting in terms of viewing the same facts from different angles. But it won't help us too much to have ethics as part of programming when we talk about neuron-based AI, because again, the programmers don't know what comes out at the other end. And the question of what kind of data they feed it is really just a question of the data that's available, and there may be or may not be some bias in culling and selecting data, but I really don't see that as the major problem. The bias that we have is in algorithms that make decision for us, and that, as I said in the beginning, is not the same as AI. I'm glad to get back to that question of algorithms. They may have the built-in, or as we say, intrinsic bias. So when we look at AI and the law, and remember please that I changed my mind on this. I think that AI is certainly something that can help us achieve fairness and justice and arrive at a situation where arbitrariness and discretionary decisions are controlled, so to speak, by a right by any citizen to say, I want the decision to put me in custody or in prison reviewed on the facts on a solely rational basis by an AI machine, whether or not the judge likes me or doesn't like me, whether there's some statistics involved, whether there's some other incentives involved. I want a purely rational decision, just like I want to have access to a DNA test if I feel that that could in any way prove my innocence. Now, there's a funny story. There's a funny story. As you said, I was actually born in Denmark a million years ago, and one of the great advantages of speaking Danish is that you can actually read Hans Christian Andersen in Danish. You can also read Kierkegaard in Danish, and you can also read a poet called Vessel in Danish. There's a very interesting poem that he wrote in the 18th century, which is The Blacksmith and the Baker. Anybody knows about that one? No? Well, you know, it is really funny. So one day the blacksmith kills someone in this small village. And so they, of course, agree, the judge and the citizens of that village agree that a trial should take place. But very, very quickly they find out that there's only one blacksmith in town, but there are two bakers. And can you imagine what the decision is of that court? The baker goes to prison. It's a very interesting story, because it really shows the application of cost-benefit analysis in our legal system, which is, of course, one of the risks if you only base yourself on pure rationality. And that is the weakness of my argument, saying that we should only look at what is purely rational. I admit that. I was at a conference organized by the Council of Europe a couple of years ago, and there was this judge at the European Court of Human Rights. And he asked, would you like to see me all replaced by a machine? And everybody in the room said, no, we would not. But I'm afraid that apart from the story that I just mentioned, I wouldn't say that I would like to see him replaced by a machine, but I would like to see a machine giving a second opinion. Now, let's just look at how we arrive at decisions. There is a fantastic book that I recommend everybody should read, even though it was written in 2003, which is this one. I don't get any commission or anything for selling this book or promoting it, but I shall at least show it to you. Persuasive Technology by Mr. Fogg, now a professor at Stanford, who developed a new science which is called captology. He coined that term, which really shows how computers persuade us to act. It's a fascinating book, and after that he wrote a few articles, and he became, of course, one of the top advisors to some of the major tech companies in the world, their business model, as we all know, being that of persuasion, whether it be persuasion for commercial reasons, for political reasons, or whatever. And some of the things that he would point as being important in terms of persuasion would be attractiveness. Actually, if you can devise a computer which is somehow attractive to you, you will get to like that computer, and you will exchange with that computer, and you will spend more time with that computer. It's exactly the same with humans. There are lots of psychology studies confirming that we tend to believe people that are good looking. It's what's called the halo effect. Completely irrational. Completely irrational. Moods. If we are in a specific mood, we can be very easily influenced. That's often used in computer technology, but not only, it's also used in the courtroom. There's a very interesting Israeli study some years ago that showed how judges were influenced by whether they were hungry or not. Judgment passed in the morning were clearly more lenient early in the morning, and then became more and more harsh as the doctors, as the judges grew hungry. Again, an example of our irrationality and why AI should be used. Now, AI is based very much on probabilities. As I mentioned in the beginning, we have this conference, and should it have been cancelled or not, from a rational point of view, it is an exercise in statistics, it's an exercise in probabilities. I mentioned the risk of driving home by car tonight, far exceeding that of dying, maybe not catching corona. In the courtroom, there are three important cases that I'd like to mention to all of you, dealing with what is called the prosecutor's fallacy. I think the first case that I'd like to mention is a case in the UK, the case of Sally Clark. Probably some of you know about that case, 1990. Sally Clark was the mother of two children. The first child died as a baby, and so did her second child. So in addition to the fact that she lost two of her children, someone arrived at the conclusion that she probably killed them. And she stood trial. And there was this doctor, statistician, I believe his name was Meadow, I'm not sure, who calculated that the probability of her committing that crime was so overwhelming that it was completely impossible that it was not her. And from memory, that probability was something like 1 to 74 million or something like that. And the jury was convinced, and she was condemned, and she spent years in prison. When finally a rational approach to this problem arrived, a statistician, a mathematician, who proved the fallacy of that calculation. And to simplify, and speaking from memory, it was something to the following effect. The probability that someone will lose a child in cot birth is like 1 to, let's say, 8,500 or something like that, based on the data available at that time. The probability of someone losing 2 children is like that number, 1 to 8,500 in my example, multiplied by the same number. And that's how we arrive at 74 million, or whatever the number was. Completely fallacious reasoning. Completely fallacious. Nobody saw that. Nobody saw that. The jury didn't see it. The judge didn't see it. The lawyers didn't see it. Because unfortunately, lawyers are not trained in statistics. I actually think that that should be part of the mandatory curriculum. We're talking about human beings here. We're talking about human life. Thomas Bayes. Everybody knows about Thomas Bayes? This is Bayesian statistics. This is elementary statistics. You don't just, if you have 2 variables of probabilities, multiply them to arrive at a total probability or likelihood. It's completely fallacious. Thomas Bayes exposed that fallacy a couple of 100 years ago. Bayesian logic was not applied here, even though it was very well known. In Bayesian logic, we have what is called a conditional probability, which is, again, to simplify the theory that if, in my example, the risk of losing a child in childbirth was 1 to 8,500, or whatever the number was I said, I'm just giving examples here, right? Then there probably is a condition that triggered that. Maybe it was the environment, maybe it was genetics, what do I know? The conditional probability was probably like 100 in the multiplier. And if you then multiply 1 against 8,500 and you multiply that against 100, you get a number that's completely different from 74 million. A major mistake. And we still see prosecutors committing that mistake. We are not rational beings. We let ourselves completely be persuaded by this kind of nonsense. Shameful. Second case I'll mention, so that's the Sally Clark case. Actually, it led to a revision of the procedural laws in the UK that banned the use of statistics in condemning people. The real question should not have been, what is the probability of this individual being guilty? The real question should have been, what is the probability of that person being innocent? And if you applied the same logic, you would have seen that if you applied that to the whole population in the UK, there would have been, again speaking from memory, maybe 20 people in the same category. Right? So there's a 5% probability that this person is guilty. And that person went to prison. It could have been for the rest of her life due to a statistical irrational error. AI could have helped on that. And after I started studying this, I changed my mind, as I said in the beginning. Another case is a Dutch case. Any Dutchmen in the room? Okay, maybe some Dutchmen are listening in here. Lucien de Berck. Also a famous case, or I should say an infamous case of irrational application of judgment. So Lucien de Berck, she was a nurse. And she was a nurse at a nursing home. And it turned out that quite a few people died in this nursing home. And it just happened to be that it was while she was on night shift. So somebody came up with, again, two books were written about this by herself, and later it developed into a scandal in the Dutch press. And somebody came up with the same irrational, non-Bayesian logic, as if Thomas Bayes had never existed. And this individual claimed that he was a statistician, which is even more shameful, and a doctor, right? So everybody believes it's true because the guy is a doctor and a statistician. Nonsense. And again, unfortunately, the lawyer who was supposed to defend her didn't have the necessary training to do so. I'm not criticizing him. I'm criticizing the system that allowed this to happen. Again, she was convicted on the same completely fallacious basis. And after spending years and years in prison, that fallacy was demonstrated beyond a shadow of doubt, and she was out, released. Now, people can make mistakes when they make judgments, but sentencing people on the basis of fallacious reasoning of a mathematical nature, when we know that it's wrong, that is completely unacceptable, inadmissible. And those who commit those crimes, they should not only stand trial for those crimes that they committed by sentencing innocent people to prison, but there should be another way of dealing with this problem, and that is that any individual in such a situation should have a human right, a procedural right to say, I disagree with the application of my fact situation, or my data situation, to your judgment. And I want that second opinion by a completely rational being, which is artificial intelligence or an algorithm. We didn't have that in 1990. We didn't have that in 1964, when another case in the US took place. I won't spend time on that one. I think I made my point. But now we have it. So I think I made my point very clear on AI and the law, AI and fairness, AI and justice. I agree that sometimes you'll find bias in it, but the bias that we find is much more prevalent in algorithms, which is the if A then B kind of equation, than it is in AI, where very, very often the programmer has no idea what comes out at the other end, and where there may be some selective data that comes in, but the quality of the data is not necessarily a consequence of the bias. It is how that data is collected, and we could have a big discussion on what rules should apply to the collection of data, but I don't think that ethics courses or anything like that is going to help on the data collection process. It will help on the algorithm, but as I just explained, it's not the algorithm that's at stake here. So that's what I would say about AI. How much time do we have left? Because I have 3 other subjects.
15 minutes.
Okay, fine. Now then let's go to accountability. Well, I already spoken a lot about accountability, but I want to say a few words about accountability as we see it now in Europe. The Commission just came out with a white paper. As you all know, the Digital Services Act is now in the works. It'll probably take 5 years before we have a final one. I think they're very ambitious when they say that we'll have some draft by the end of the year, and I hope it'll be the case. But I'm afraid that it'll be just as controversial as the GDPR, with just as much lobbying and maybe even more than in the GDPR. And that's okay by me. I mean, that's part of the legislative process. But I'm just very skeptical that we will see a new Digital Services Act within the year. So what we are left with is the existing e-commerce directive, which everybody knows about, and the dichotomy, the conflict between that and the Communications Decency Act in the US. I wasn't here yesterday, but did anybody speak about that yesterday? The Communications Decency Act in the US? Okay, because I think I'll just mention a few words about that, because it's also important for the different freedoms that you mentioned in the introduction. The Communications Decency Act in the US from 1996, Section 230C, is something that everybody in this room and everybody listening in should really study. It is the basic accountability, or rather immunity rule in the US. It is even more important for the internet, and therefore also for artificial intelligence, as it were, than the First Amendment. You may say that it's become the Bible of the internet. And to simplify, what it says is that the search engines and the social media are not responsible for content. They're not publishers and they're not editors. Under no circumstances are they. Even if there is a judgment, Now, there cannot be a judgment in the US, but there could be a judgment in a European country, and I'll get back to that. Now, what we have, of course, in Europe is the e-commerce directive, as I mentioned, which in Articles 12 to 14 and 15 talk about the actual knowledge threshold if a provider has actual knowledge of harmful content, then that actual knowledge may attract liability or accountability. And there's a big debate going on right now in the US. The Department of Justice actually organized a roundtable a couple of weeks ago. I don't think that anything is going to happen up to the elections. And the big debate in the US seems more be turning now towards dealing with concentrations. I know that Elizabeth Warren, who unfortunately is no longer in the race, had heavily argued for breaking up some of the big tech companies because of their concentration. But in terms of debating whether 230 should be changed or not, it's not really part of the political conversation in the US. So if a change comes, it'll have to come from Europe. Which brings us to the question of hate speech, which is one of the major subjects in the intro. The two leading, I'd say, member state laws on hate speech in European Union, as you all know, are the German law and are the French law. The German law entered into effect on the 1st of January 2017. It's the Netzdurchgesetz, which now is under revision. And the French law passed this year. Actually, it passed the National Assembly in July of last year. Then it went to the Senate, and then it just passed in January. And the latest news I have, I've been heavily involved in that law. The latest news I heard was that it would enter into effect in April. I haven't seen that. It's news that I've heard. You may wish to double check that. I cannot be sure. Now, what is very interesting in that French hate speech law, and I think that my article about this may have been distributed by you. Perfect. Which I wrote for the American Bar Association. What is very interesting about this French hate speech law is that in the so-called travaux préparatoires, the member of parliament who proposed the law, Laetitia Avia, actually cites Macron's sort of agenda or roadmap on accountability, saying that the position of the French government, I believe that that's the way it's phrased, is that with the new Digital Services Act should include a third category of providers on the internet. So what we have are the search engines and the hosts, or the ISPs, the access providers and the host. That's what it was in year 2000. And the third category should be the companies that cull content. And of course, what he's thinking about here is big social media companies, where the control over the content is not just we are putting in place a platform and you guys put onto it whatever you want. That's not the case. Today, on most social media, and I will try not to mention names, you all know that what you get on your news feed is something that is packaged for you, something that's targeted for you, based a lot on the research done back in 2003. Persuasion. I personally don't have a problem with that as long as it's just commercial. But obviously, the theory that these media are just passive and just platforms is no longer a reality. So the position which is reflected in the French hate speech bill in the travaux préparatoires is that the French government's position, as far as I understand it, is to create the third category, which would hopefully find its place in the new Digital Services Act. That, of course, is going to create a major, almost geopolitical problem between the US and Europe, which is already there. I mean, I've had several cases where I obtain a judgment in Europe, defamation, typically it's defamation. It could also be now hate speech. It could be hate speech under the German law, it could be hate speech under the French law, and laws that we see in other countries coming up. And I can't enforce it in the US. I can't enforce in the US because, as I just said, the Communications Decency Act, these companies are based in the US, as you know, gives them complete immunity. And based on a law from 2010, and that was Obama, which is the Speech Act. I think you should all read that one. It's actually illegal, if that's not the word used. Well, actually, I think it is. To try and enforce foreign judgments on defamation in the US. So just attempting to have a judgment recognized and enforced in the US will trigger sanctions against you. Those sanctions are at least the legal cost. So if you get a judgment saying that certain content should be taken down because it's hateful, it's hate speech or defamatory, final judgment, no longer appeal, and the author, for whatever reason, decides not to take it down, either because he's personally bankrupt, I had a case like that, or he's in another country, or he's just vengeful, or he's just a psychopath. You know there are psychopaths out there? And suddenly these psychopaths have a weapon of mass destruction, which is this. They destroy lives. So they decide, no, they'll just leave it up there. They don't care. And then you try, of course, in Europe now, under the GDPR, you can either use Article 16, which is the right to rectification, and or Article 17, which is the right to be forgotten. By the way, I just read the day before yesterday, there was a fantastic judgment in Sweden that the Swedish DPA, in excess of 9 million euros for Google refusing to comply with the right to be forgotten decisions. Fantastic. Well, anyway, small digression. So you have these decisions in Europe which will allow someone, the victim of defamation, the victim of hate speech, to have the information either taken down and or dereferenced from the search engine, which is typically Google. But it's still up there if you go on .com, right? .com, which is not a European domain name, like .fr and .dk and .de and so on. .com is not European, but it's used by everybody. So if you go onto that version of the search engine, it's still up there. And if you try to enforce the judgment because the author is a psycho and just leaves it up there, first of all, in the US, you cannot enforce it. Second, you risk having to pay legal costs because you're trying to do it. Did everybody understand what I just said? This is the situation today. Now then you have companies like Google, and every 6 months, I think it is, they publish what they call a transparency report. You should actually look at that. In that transparency report, you see lots of very interesting stuff, like different governments asking for information on this and that and so on. It's a good idea. I'm not against transparency, on the contrary. But if you look at the section which deals with complying with foreign judgments, and you'll see the countries where you are from. You know, I'm from France, so I'm interested in that. But you just look up the different countries, and you'll see judgment passed in your countries for defamation, and very soon for hate speech, where sometimes, I should say, typically, I've got to be fair here, typically, Google decides at their own accord that they will comply, I say comply because they're under no legal obligation to do so, with the court judgment of a final nature. Because they're nice people, right? I mean, come on. So we leave our destiny, our legal destiny in their hands because they want to be nice. But the worst part of it is that sometimes they're not nice. There's a fantastic one that I found on their transparency report, which deals with a judgment from France. I think it was from France. Anyway, it was a European member state. So there was this judgment that a certain number of URLs should be taken down because they were defamatory. Let's say it was like 116, whatever the number. And Google then reviewed the judgment of the sovereign state's ultimate final decision judiciary, right? And said, we don't think that the premises and the facts that we can see from this judgment actually lead to dereferencing more than 86. I'm just giving a number here, right? Out of the 116. Come on, what is that? So suddenly they are the judges of the judges? Doesn't work. Doesn't work. I'm sorry, it doesn't work. So we need, from Europe, not only to develop our own actual knowledge within the Digital Services Act theory, which will be much stronger on this third category, this new category, which did not exist in year 2000, which is this social media that packages information, that targets information, that does much more than just put a blackboard at your disposal and you write on it what you do. Might have been true in 1996 when the Communications Decency Act was passed. Might have been true in year 2000. This book about persuasive technology, again, is from 2003. So that might have been true. It's no longer true. And we also need to be very active in Europe. I'm sure that the Commission will do that in promoting this idea. It'll be after the elections in the US. Now, probably the last subject that I'll talk about today, which could actually be the most important, and that is the accountability of private corporations to comply with human rights. There's a lot of literature about that, and out of the books that I read, which I think is one of the best that I read recently, is this one. Again, I get no commission for showing this, but I think everybody should see it. It's We the Corporations, How American Businesses Won Their Civil Rights, Adam Winkler, published about a year ago. Fantastic analysis of how private corporations actually have, in the US they call it civil rights, and in Europe we call it human rights. Actually, under the European Convention of Human Rights, you'll find certain sections that talk about legal personhood or legal personality. So corporations are protected by human rights and by civil rights, but they are not obligated under them. Unless the human right or the civil right, in addition to being included or stipulated in a treaty, has somehow been transposed into national law, then they can get away with it. There is, of course, the famous UN policy guidelines, the Rutger Principles, which talk about the obligations of transnational corporations to establish a human rights impact study of whatever they do, in principle. But these are just guidelines, and these corporations may or may not do them. There is no sanction against it. There's a very interesting case right now involving complicity in war crimes. This is a case involving the Rohingyas from Myanmar. To what extent social media companies that had knowledge or should have had knowledge of the incitement that their platform was used for, leading to genocide, to what extent they are complicit in war crimes or crimes against humanity or even genocide. Very, very interesting case. So far, we have some cases dealing with corporate liability for war crimes. Very recently, there was one in France, the Lafarge case, involving payment to certain groups that facilitated business in Syria. What I said here is not precisely all the facts, but I think that everybody gets the message. And we also have other cases like that, but it's It's far from clear when private corporations are accountable even for war crimes, even for crimes against humanity. And let me just, one last remark, because I think that the 5 minutes are probably over in 30 seconds. When you deal with these private corporations and you challenge them on why they feel that they should not be accountable for whatever happens on their website, incitement, genocide, hate speech, defamation, the argument that you very often hear is that, sorry, there's so much going on our platforms, we have 2 billion people, and we have 500 million messages coming up every hour. How do you want us to make sure that nothing illicit takes place on our platforms? What's wrong with that argument? You know, actually what they're saying, just think about it. Actually what they're saying is that success justifies harm. Think about it. That's what they're saying. We are so successful that we really cannot put in quality control. We put a drug out on the market, and the demand is so great that, okay, sometimes it's toxic, but simply our quality control could not follow the demand. So, innocent, completely, not accountable for anything. Sorry guys, that doesn't work with me. Success can never justify harm. On the contrary, if you are a successful corporation, you better get your quality control in place. Never have I seen that argument work in any other industry. And with those words, maybe we should take some debate.